Good afternoon. Welcome. Thank you for joining us at Venable today. And also, for those of you who are on the webinar, thank you for joining us. My name is Eric Berman. I'm a partner here at Venable in the nonprofit organizations practice. It is my pleasure to present our discussion entitled Avoiding the Legal Pitfalls of Charitable Fundraising. Before I introduce our two speakers, let me quickly take care of some housekeeping issues. First, we've decided to do things a little bit differently today. I know that some of you have been to these presentations before. You're familiar with the drill. We usually do these as a luncheon earlier in the afternoon. And today we decided to start later in the afternoon and segue right into the highlight of the evening, which is our cocktail and networking reception, which will start at around 5:30. That'll be right where you came in, and we'll also have use of our balcony, and I think the weather's cooperating, so that'll be nice. And in keeping with our late afternoon, more relaxed, casual theme, we've absconded with the normal presentation table, and we're fashioning this as a fireside chat amongst friends. Just a little light chatting about charitable fundraising, as we are wont to do. Number two, as you know, for those of you here in the room, in the Trade and Professional Association community, we do offer continuing education credit. If you have any questions about how to obtain your CAE credit, Camille King is sitting right up front here, and we'll be happy to help you. Normally, we preview the next two or three presentations, but we are going to take a bit of a summer respite from our July and August presentations. We hope you do as well and enjoy your summers. We will be returning on September 20th with a very interesting presentation on donor-advised funds. What's the fuss? And stay tuned for more information on that shortly. So now on to today's discussion. As I mentioned, we'll be talking about issues involving charitable fundraising, a topic that seems extremely relevant and timely. I'm sure most, if not all of you, heard the news today that the New York Attorney General, the Charities Bureau, has filed a lawsuit against the Donald J. Trump Foundation involving fundraising activities. I think the foundation raised about $2.8 or $3 million. So this is quite literally front page news, very relevant. And this is something that the state regulators have been focused on for years, as well as federal regulators. People don't always appreciate the role that the Federal Trade Commission plays in charitable fundraising, because the FTC doesn't often interact with charities, but in this space it does. And so, this is something that you want to do right, even if there is some scrutiny and even if there is some risk. Charities need to raise money in order to implement their charitable programs and support their missions. So you want to do it, you just want to do it the right way. I cannot think of two better people to help us do it the right way than the two people sharing the stage with me. Yael Fuchs, to my far left, is the co-chief of the enforcement section of the New York Attorney General Charities Bureau. She will not be answering questions about the lawsuit that was filed today. Maybe during the cocktail reception after one drink. see what you can do. Yael oversees the efforts of the enforcement section to investigate and litigate violations of New York law governing not-for-profits and their agents, of course, including fundraisers. She also serves as the vice president of the board of NASCO. As many of you know, that's the National Association of State Charity Officials. She's also an adjunct professor at Cardozo Law School. Yael very kindly traveled down here this morning from New York. We always appreciate seeing you. Love that you're here. Of all the people who sue my clients, you're my favorite. So thank you for being here. To my immediate left is Atitia Rock, a familiar face to many of you. Atitia is the Associate General Counsel at the American College of Cardiology. Today is a bit of a homecoming for Atitia. Until recently, when she started her in-house gig, Atitia was one of the star lawyers in Venable's nonprofit organizations practice. She effectively oversaw our client portfolio when it came to charity fundraising compliance, registration, renewal, contracts, and counseled some of our largest and most sophisticated clients on all manner of business practices. And prior to Venable, Atitia was also in-house at the Legal Services Corporation, where she actually helped launch their fundraising efforts. So a very esteemed group of speakers with us. And we call this a loose agenda because I really think that there'll be a lot of discussion back and forth rather than just sort of talking at you. But loosely, we will attempt to hit our marks. We'll start by talking about the regulatory landscape for charity fundraising. What are we talking about here, right? Let's define our terms: charities, professional fundraisers, fundraising counsel, commercial co-venturers, terms that you've heard of. What do the regulators regulate? Everything from traditional fundraising models like telemarketing, direct mail, to newer high technology platforms, crowdfunding, GoFundMe, mobile giving, online, even virtual and augmented reality. We'll say a few words about private regulators as well. The Plaintiffs' Bar, the TCPA, Telephone Consumer Protection Act, Plaintiffs' Bar is showing signs of increased activity against charitable fundraisers. And then we'll hit some other business considerations, donor intent, IP issues, who owns the donor list, things like that. And then hopefully we'll have time at the end for sort of wrap this all up in a nice bow with a compliance checklist. So why don't we get started? Atitia, why don't you start us off? Why don't we sort of just go over what we're talking about here, who gets regulated, how many states, how burdensome is this really, and let's just get going.
Sounds good. Thanks for having me, Eric, and Venable. It's great to be back here doing this presentation. So let's start with paving the rules of the road and talk about who's being regulated in this space. What does it mean if you are a regulated entity? So the first most obvious entity that's being regulated here are the charitable organizations. Typically, your 501c3 organizations that are soliciting funds for a charitable purpose are regulated, and state definitions of charitable organizations and soliciting for a charitable purpose, though, can be a little more broad and encompass other types of organizations that you wouldn't typically think of. So, for example, the Arkansas statute broadly defines charitable organization to include social welfare organizations and advocacy organizations, which fall under 501c4 of the Internal Revenue Code. If you are a 501c6 organization that is soliciting contributions for a specific purpose, charitable purpose, such as an educational purpose, you might be a regulated entity in this space. So if you are a charitable organization soliciting charitable contributions, what does that mean for you? 39 states and DC currently require organizations to register prior to conducting solicitations. I've had a lot of clients come to me saying, "Oh, I didn't know this, was a requirement. Are we going to be in a lot of trouble? What are the penalties?" Fortunately, regulators want to see organizations comply. And so as long as once you become aware that these registration requirements apply to you and you take the steps to quickly get registered, then they're not going to hit you with nasty fines.
I will just say that my first exposure to charity regulation was in my first job out of college before law school, where I worked for a small nonprofit that was located around the corner. It was down the street from the Hay Adams. And I was a bright and bushy-tailed new program officer, one of those very DC type words. And I decided that we would add an appeal for funds to our monthly newsletter. And then we started getting cease and desist letters from various states because we had never registered as a fundraising organization. So little did I know that several years later, I would be the one sending out those letters.
And I will be sure to remind you of that every time that you reach out to my clients.
And right, that's exactly what happens. If a regulator finds out that you, or catches wind that you are an organization soliciting charitable contributions and you're not registered, typically they will send you a letter saying, hey, we've been made aware that you're soliciting, you need to register within 30 or 60 days. The worst thing you can do is ignore those letters. And I've had clients say, we've gotten these letters for months and months and months and we haven't done anything with them. And the first thing I tell them is, let's call the regulator and tell them that we are taking steps to come into compliance. So don't ignore those letters.
And I'll just chime in and say, as someone who's still on the defense side, this is very useful comfort. I have clients, and they're not bad actors, but they've had a business model. Nobody in this room they've done things a certain way. They've done it a certain way for many, many years. And, we're brought on to advise, and we say, it looks like you ought to be registered as a fundraiser or a council. And that's the concern is, well, if we do things correctly, are we sort of popping our head up from the ground like a weasel and we're going to get batted. And the regulators are not here to play a game of gotcha. They really do want to help you comply, in almost all circumstances.
So the first step is to register. And then, unfortunately, you can't just register once and then forget about it. There are annual renewal requirements. So Venable offers assistance to clients with these registration renewals to make sure you're not slipping through the cracks with these deadlines. There are other firms and companies the registration service firms that assist organizations in this space. It's an easy area of compliance, so don't ignore it. And then once you register and renew annually, as part of the renewal efforts, you have to submit financial reports. This is a way for the regulators to ensure that they know what funds are going to the organization and how the funds are being spent, that they're being spent for the nonprofit mission and purposes, not for, to fund the president or CEO's cars. And so there are financial reporting requirements. There are also solicitation disclosure requirements. So when you are asking for money, there are certain disclosures that need to be provided to inform the public of, here's where you can obtain financial information about the organization. Here are some registration information about the organization to show that you are a legitimate charitable organization doing things the right way. Anything to add? You mentioned C3s, and that I think it is important to know that for most states, the definition of a charitable organization is not a perfect fit with a C3. And so it might include C4s. In some instances, it might include C501, C27, that's the PAC, right? What we're seeing actually, this is a little bit of, kind of cutting edge insight in the enforcement arena, is we're seeing sham PACs. So organizations that instead of calling themselves a C3 and using popular causes like veterans and cancer and first responders are calling themselves PACs, and that takes them out of the state charity regulation, or so they think, and puts them under FEC, the FEC umbrella. But in some cases, the definition of charity or charitable solicitation is sufficiently broad that they might still be subject to state regulation.
That's a very good point, and we might talk about TCPA later, but there's also not exactly uniformity between the state and the federal level. Under federal law, by definition, it is a charitable solicitation is not a telephone solicitation. It is not a phone call designed to induce the purchase, rental, or investment in goods, services, or property. But in some states, charitable solicitations explicitly fall within the definition of telephone solicitation. So you really need to keep both federal and state in mind, and then within states, there's no uniformity. Excellent point.
So we have a question.
Oh. There you go. Oh, you have a question. Hi, I have a question.
Thank you for what you shared. It's specifically about the registrations. Now, my current organization, my previous one, would like to look at where they received donations from the year before in order to determine where they should renew in the next year. As a solicitor, I would send out appeals online, so I felt we should be registered in every state. Mm-hmm. Could you speak more to that and whether or not that is what is the best practice about renewing your charitable registrations and whether online appeals do impact those registrations? Thank you.
Sure. Online solicitation, so the first answer is it might differ state to state. Generally, it's kind of a minimum contacts test, and that has been codified in what's known as the Charleston Principles. So not all states have signed on to the Charleston Principles. They're considered to be guidance, and basically they set out the minimum contact standards when it comes to online solicitation. So of course, if the charity is based in a particular state, otherwise, if it's just soliciting online, is it specifically targeting residents of that state? So, for instance, if you are a disaster relief organization and you are going to then target states where there was a natural disaster, that might then put you on the hook for solicitation in that given state. Do you have a disproportionate or a significant, I think is the word, amount of donations from that state? So those are the types of considerations that regulators will look at.
And that second piece, is are you receiving repeated, substantial contributions? That's more on a looking back basis. It's easier to look back at the past year to see where you're receiving your contributions so that you can determine, we should renew in this state because we're receiving substantial amounts of contributions from citizens of this state.
One thing that I'll add is there might be an advertising component to this, which is sort of where I come from this a lot. If you find that in looking back at previous donation data, 5 states in particular have really been sources of donation, and your solicitations, the content of the solicitations say this is going to help local XYZ. But in fact, your organization disperses donations nationally. That will probably run afoul of just basic deception laws under either charitable solicitation statutes or baby FTC laws, we call them, false advertising statutes.
All right, so let's talk about the next category of regulated entities, fundraising professionals. These include professional fundraisers and professional fundraising counsel, depend on the state. They may be referred to as a paid solicitor or a fundraising consultant. So a professional fundraiser is someone who is getting paid by an organization to go out there and actively request contributions for the organization. Fundraising counsel, on the other hand, they're being compensated by the organization to do all of the behind-the-scenes work, pretty much everything leading up to the ask. So advising on strategic development issues, targeting donors, helping with your mailers, putting together phone scripts for phone solicitations. And similar to charitable organizations, there are registration and renewal requirements for fundraising professionals as well. This is to protect the charities, to make sure that they're working with fundraising professionals who are legitimate. They're out there to help organizations, not to work with organizations and then take 90% of the fees that are the funds that are raised. This is a way for regulators to ensure that, again, there are legitimate fundraising professionals working for charitable organizations.
I have to interject, not because of my client base necessarily, that high fundraising costs on their own are legal under the First Amendment. Having said that, you have very little room to maneuver in the way you solicit donations, because what can you accurately and honestly say the money is going to? That has been my public service announcement. Please continue.
Right. And one of the questions that I would frequently get asked by clients and prospective clients is, if we pay our are we allowed to pay professional fundraisers on a percentage basis instead of a flat fee? And the answer is the law does not prohibit an organization or a fundraiser from being compensated on a percentage basis. However, the Association of Fundraising Professionals, that is one of their prohibitions. So it's not legally prohibited, but it's frowned upon in the fundraising industry. And then the next category of regulated entities, which is my favorite, commercial co-ventures. My favorite because, I worked on these clients with charitable organizations and for-profit entities, and then get to see the marketing efforts, whether it's on radio, TV, print. So it's a fun area to work on. And, you used to see a lot of commercial co-ventures, which are relationships where a for-profit company is advertising or marketing that the purchase or use of its goods or services will benefit a charitable organization. It used to be, they all used to look very similar. And as the years go on, we're seeing, different fact patterns. People are trying to be more innovative in this space, and they're running with it. So I think it makes it a little trickier to regulate and navigate this space.
Is anybody in the room working on a part of a CCV now? Is this an issue that's come up? Yeah. I mean, when I was introduced to the concept, it was, every dollar of your purchase price of a bucket of chicken goes to Susan G. Komen or something like that. And now it's, as Atiti is noting, it's the permutations are really challenging, I think, to regulators.
Yeah, I think there was a fact pattern at a recent NASCO conference, which I know sounds scintillating, but for some of us, it's actually quite exciting, that involved a gaming app where the user had to battle monsters, and you could buy various weapons in order to do so. And whenever you bought a golden sword, 50 cents would go to a charity, and the makers pick the charity based on the zip code of the person, of the user, so that it could be local. And then we were all supposed to try to figure out, who was supposed to register, what do we care about as regulators? Because there's a lot of consternation, I think, on all sides right now. It's very much an area that is in flux. And there's a lot of questions about whether or not new regulations are necessary, or whether this is really traditional fundraising in, high-tech guise. So I think we'll talk about that more. It's an ongoing conversation.
That NASCO fact pattern has me cringing just on the privacy and data security issues alone.
Yes.
Let alone the CCV is the least of it.
Yeah, I think one of the speakers it was a tech lawyer in San Francisco who represents a lot of these guys. And at the end of the panel where they had various permutations of this fact pattern, he was like, and I just told them no. just don't do it. But as Eric and I have discussed, there's a real tension there, because the regulators, we don't want to stymie innovation. But we are naturally risk-averse, skeptical people. And so we might be a little bit more aware of some of the potential for abuse than the millennial game programmers.
Very good point. And I think I think the counseling point for those of you where you're thinking about CCVs and wondering what the issues. We were talking offline about this. Due diligence on the part of each partner to the CCV is crucial, and we see it from both sides, right? We represent the brands, make sure this is a legitimate charity. On the other side, as you all know, a lot of our charitable organization clients are highly sophisticated, even though they are technically not the commercial co-venturer, the brand is. sometimes the charity has to hold the for-profit company's hand and make sure, are you registered? Does the contract say what it needs to say? So you really need to do your legwork from both sides.
Yeah, if I can elaborate on that, I mean, I think CCV is also one of the areas where the states differ the most in the amount of regulation. New York, for example, the commercial co-ventures don't have to register, but you have to have a written contract, just as you do between a charity and the professional fundraisers or professional fundraising council. And at the end of the campaign, the CCV has to provide an accounting to the charity. And then the charity needs to report that to us in their annual reporting. But the due diligence factor for me is really important. And I'm going to back up a second and say that the views I'm expressing here are my own and not that of the office, and that I am not here to provide legal advice or pronouncements on New York AG policy. That being said,
having said that, I was going to say, give us legal advice.
What kills me is when we see what we would consider to be a sham charity that has managed, with that caveat, because that's, I guess, could be subject to litigation, but that has managed to also insert itself and raise money through an unsuspecting or not all that diligent for-profit. So, for example, there was an instance of a very large, very sophisticated food service provider that, as part of its community engagement program, worked with local charities, and the charities could send volunteers to work at concession stands, at events, at concerts, at ball games. And so this was, instead of having like a community car wash, you would all go and, work the beer and serve hot dogs. And the profits from that particular stand would go to the charity. Sounds great. But the only thing that the for-profit did to vet its charity partners was check to make sure that they were 501c3s. Now, we all know that the IRS gives out C3 status like candy on Halloween. That does not necessarily ensure legitimacy. In this case, it was a totally bogus charity founded by a guy who then also cheated these local high school students, told them that they were going to get paid like $9 an hour for working at these food stands, and pocketed the money. So he spread out the lies. The for-profit got lied to, the kids got lied to, and he eventually got convicted. But I spoke with this entity, and I really think that a little bit of due diligence in terms of knowing that the charities have to be registered by the state, and just, Googling would have gone a long way.
I was just going to say that the internet is your best friend. It's the easiest way to due diligence and, look at the charities or the for-profits. I had clients who would say, we have this exciting opportunity to partner with this charity. We want to conduct this CCV. And then I started looking into the charity and realized that it was, in one case, a charity being run out of someone's home. So not exactly legitimate. Regulators are making information available through these charity search databases online on their website. So you can easily go onto the AG or the Secretary of State's website to see if a charity is registered, or even if a professional fundraiser or commercial co-venture is registered. So use the internet. It is your best friend.
And I would just like to hammer home, if I may, you all are sophisticated actors. You're here. There's an aspect of preaching to the converted here. But just keep in mind, for your local affiliates, for partner organizations, things that you take for granted, it just may not be the case all the way down the line.
I can only add more of the same. 2 weeks ago, I got a call from a potential client facing an AG and FTC issue. This was the charity. The head of the charity told me who they were using as a fundraiser. I Googled the person's name. The second link explained to me that this person is banned from fundraising in the state of New York, and that wasn't very difficult to find. So we've already started kind of talking about this, but let's keep the conversation going. My introduction to this space was a few years ago, and it was the Cancer Fund case, which was very high profile. It was the first joint Federal Trade Commission, 50 state plus DC, every attorney general enforcement action against charitable organizations. And I didn't need to be convinced that the states coordinate with each other and coordinate with federal regulators. That wasn't always the case, but it certainly is now. And if anything, I think coordination is increasing. But let's talk a little bit more about that.
Sure. I would say that we do very much see our role, and I think most states do see their role, also not just enforcement, but also compliance and cooperation. And there really is, as Eric mentioned, there's a real desire to work with the sector, both out of the goodness of our hearts and then out of pure practicality. I think there are 80,000 organizations registered in the state of New York. We can't review all of their filings. We can't investigate all of them. And we really rely on the sector to be self-regulating. And I think a lot of the rules and regulations are really intended to promote that. If you have to file an annual report and you also have to submit an audit, that's going to be good for your organization. It's going to promote internal compliance and internal communication. We really would prefer to work with you on a compliance basis rather than on an enforcement basis. There is, of course, increased enforcement activity. And I think an increasing awareness and appreciation for the dollar figures at stake. And I think for the real harm that the fraudulent, that the bad actors do to the sector as a whole. And so we hope that our enforcement actions are actually reinforcing public faith in the sector. So there is more communication. NASCO has become increasingly active. The National Association of Attorneys General now has a charities subcommittee. So we have the attention, more of the direct attention of state AGs. And there is this single portal coming, which will allow charities to all register in one place, which will hopefully really reduce the regulatory burden.
The single portal has been coming every year for the past 5 years.
I know. I think it's really happening.
I had hair the last time the single portal was put up.
Will that involve all states or
The first iteration is going to be a pilot program. So it's going to be rolled out to a group of states. It is actually under a separate C3 whose initials I am forgetting, but I'm happy to provide that information.
The annual NASCO conference is really the only one that has a permanent place on my calendar at this point. If you are involved in any way in charitable fundraising, I would commend you to put it on your calendar. It's usually a 3-day conference, the first day of which is open to the public. And you get some face time with regulators. You hear their thoughts on compliance. It's better to sort of mingle and be seen as a good actor than the other. So I think NASCO is worthwhile. I've learned a lot from there.
And I'll say we are really interested in finding out what are the issues that you're dealing with. And as we'll talk, there's still a lot of regulatory attention on what we in New York call the bottom feeders, the real outlier charities who are essentially shell organizations. I'm happy to say that those are outliers, and there are many other issues that are relevant to the sector. With respect to regulation of fundraising, As Aditya was saying, there are the registration and the reporting requirements. You should all know or be aware that there are also books and records requirements. Again, the requirement of a written contract. And one thing that I think is interesting that the New York statute provides is this mutual liability, or again, I think a desire to have everybody watching everybody's back. So the charity could be liable if its fundraiser isn't registered and vice versa. So it really behooves you to make sure that all of your counterparties are properly registered.
Because as part of the charity's registration requirements, you're to disclose relationships you have with your different professional fundraisers and commercial co-venture partners. Same thing with the professional fundraisers. They are required to disclose and submit copies of all the contracts with the charities who they are providing services to. So this is one way for the regulators to check that each party is doing their part.
So let's just say a word about the Federal Trade Commission. If I had $1 for every time I heard something along the lines of I'm a charity or I'm a charity fundraiser, the FTC can't touch me, I could probably retire by now. People don't really appreciate the role that the FTC plays. It is true that by statute, the FTC's jurisdiction is limited to corporations organized for their own profit or that of its members. So typically, the FTC is not going to bring enforcement actions against C3s. It certainly does against C6s, for example. There's a litany of antitrust cases in that space. It is not controversial at this point to say that the FTC can very easily go after for-profit fundraisers that raise money for charities. That issue was litigated about 15 years ago when the telemarketing sales rule was amended. And the decision was pretty clear cut. In some cases, the FTC will go after charities directly, and typically in the case that Yael has mentioned, where they view the organization to be a sham, even though it is designated as a C3, it is really not organized for a charitable purpose, but rather to benefit its owners. And what are we looking for? Does a single family run the charity? Everyone on the board is related. There's a staff of 9 people, and the organization pays the executive director $500,000 a year. These are warning signs. In my experience, typically what happens is that state regulators, where there is no jurisdictional prohibition, they begin investigating wayward C3s. And in response to a subpoena or civil investigative demand, the organization will start producing documents, oftentimes financial records, credit card receipts, and the state regulators will look at these and say, why was this money spent on this? And if it looks like this really is taken out of the realm of legitimacy, they may bring in the Federal Trade Commission, which has good resources, and particularly out of their Seattle office, they really do focus on the space. Just this year, back in January, the FTC brought a case against a political and charitable fundraiser, Infocision. I believe Infocision paid $250,000 to settle that case. That was about deceptive solicitations over the phone. So this is recent. I mean, I'm aware of non-public investigations that are going on right now involving the FTC. So it's not. I think I tend to think of the states as sort of the collective 800-pound gorilla enforcing, but be aware of the feds as well.
Another type of regulator that's not on this slide, not a state regulator, not a federal regulator, but someone else who's watching charitable organizations and professional fundraisers are watchdog agencies.
Good point.
You have the BBB Wise Giving Alliance. Charitable organizations must meet certain standards to be accredited and use the seal, the BBB Wise Giving seal. There's also Charity Navigator. They pull together and look through an organization's Form 990, and they have a rating system for charitable organizations. So these watchdog groups are out there regulating this space as well.
That's an excellent point. So let's start out by talking about regulation over traditional fundraising, telemarketing, direct mail. I think that telemarketing is still the most highly scrutinized form of charity fundraising. You could check me on that, but the last thing I read says that there seems to be something unique about calling people over the phone that is ripe for abuse in a way that direct mail, even you could open up the mail and just throw it out. And what's going to happen? But let's talk about enforcement in that space.
Sure. And again, the title of the talk is Avoiding the Legal Pitfalls. And as you all might be aware, there are certain disclosures that need to be made in any sort of telemarketing. Those may vary by state, but they're generally things like identifying whether or not you're calling from the professional fundraiser or from the charity. You don't need to disclose the percentage or the fee arrangement with the charity. But of course, if asked, that needs to be disclosed. I think in New York, you also need to disclose whether or not the money solicited will then be subsequently granted to another organization. You're supposed to describe the program in clear terms. So it's worth looking at the individual state disclosure requirements. In terms of enforcement, I think we do find, especially in this day and age, that there's a certain part of that market, and I don't know what the percentage is, that is really targeting the elderly, targeting, other vulnerable populations. We get complaints from caregivers saying, my mother has been paying $20 a month to this, bogus charity, or they won't stop calling her. They call her 5 times a day. So there's kind of this really ugly element of elder fraud and elder abuse there. And then there's also, the harassment aspect. And so I think it's really, we consider it to still be, an area that's very much worthy of regulatory scrutiny. I think, like it says, that it implicates basic false advertising principles. So there's puffery, which is, there's good marketing, which is, of course, permitted. There's puffery, which starts getting you closer to the line. And then there's deception. And if you claim that you help Vietnam veterans, but in fact, and you provide them with emergency assistance for rent and groceries, but in fact, you are pocketing the money and paying young women who are not Vietnam veterans, because the math doesn't add up, and going to nightclubs, then you are the president of the National Vietnam Veterans Foundation, and we will shut down your organization, and the FBI will investigate you and send you to prison. That was a pretty bad fact pattern. But there are too many organizations that fit that model.
But if the charity's program was to help wayward young women, that's the solution.
And they disclose that to the callers, and people gave the $20 specifically
Indeed.
for that purpose, then we'd have a harder case to make. Yes. Eric mentioned, and of course it's true, that the percentage of money that goes to the charity cannot be regulated. There's Supreme Court case law on that. We've seen that come up in the telemarketing context. We've seen that come up in the clothing bin context quite recently. The Supreme Court ruled that solicitation is charitable, is speech protected by the First Amendment, and having a bright line rule on the percentage doesn't meet what's known as strict scrutiny. It's not closely enough related to the governmental interest in preventing fraud. So that's not the way to regulate it. What we have seen, and you'll see the bottom feeder there in New York's Operation Bottom Feeder, is that where you have an organization that relies on high percentage contracts for an extended period of time as their sole source or their primary source of fundraising, if you peer under the hood, you're going to find fraudulent representations, you're going to find non-existent boards, you're going to find charitable funds being used for personal reasons, and that's the type of organization that we're going to go after.
And if memory serves, the last of the trilogy of the Supreme Court cases that talk about the First Amendment implications of a percentage going to a fundraiser, which is the Madigan case. No, high fundraising costs by themselves can't form the basis of an enforcement action, but they can be indicia or supporting evidence that can entitle a state regulator to bring a case. So It's sort of a plus factor.
Right. I mean, and what I always say, I think there was kind of this out-of-date debate for a while between the regulators and the sector where, the regulators came out with cases against charities that used high percentage fundraisers, and parts of the sector said, wait, it takes money to raise money. Don't perpetuate the overhead myth. Please, regulators, you're looking at fundraising overly simplistically. My hope is that debate is kind of a thing of the past, because I think that regulators get it. We know that charities need to have overhead costs. If you're going to comply with all of the regulations that we're imposing, you're going to have some sort of back office function. You have to pay your chief compliance officer. So we understand that. My mic's sorry. But again, where and even when it comes to fundraising campaigns, there might be a loss leading campaign, there might be a donor rousting campaign. But when all of those factors are put together, when that's the only way that you make money, it's not an issue of startup costs, then more likely than not, there are going to be other issues.
One thing I've heard from the FTC on this is, okay, we get it. In year one, the fundraiser has to get 85% of the donation because they've fronted so many of the costs that this really is a loss leader. But once you have sustained donors, your sunk costs are your sunk costs, but the marginal cost of calling them again goes down. So why didn't you write your contract so that it's 85% in year one, 75% in year two? You're never going to get down to the number that regulators want to see, which is probably closer to 30%. But that's a better fact pattern.
Well, and speaking of which, I guess a point of caution is also marketing pitches that assure donors that X percentage of the revenue will go to programs. I think that's a number, that can be fudged. It's sometimes in legitimate ways, but there are charities out there that are really getting into trouble because they are aggressively using things like gift in kind valuation. Is that a term that you all are familiar with? So if you're accepting and donating goods, non-cash contributions, you need to value that. So you need to ascribe a value to the clothing, to the pharmaceuticals, to the food. And that needs to be fair market value. So if you are collecting pharmaceuticals and then shipping them overseas, is the fair market value the US price, or is it the overseas price? Those can differ dramatically. And the significance of that number is that it's going to impact your revenue and expenditures. So it's going to then impact your ratio, how much of your donor dollar goes to program services. So I think you get tension sometimes within departments of large organizations where, the development department is going to want you to say that 90% of your donor dollar is going to programs, when in fact, if you valued the goods correctly, it would be something lower. And that is something that regulators are looking at. I
think that's something that Titi is going to learn in her role as an in-house lawyer. Sometimes in-house legal is considered the mortal enemy of the business people or the salespeople. We have a question.
name is Carolyn with Food and Friends, and I actually think the conversation in development departments is really shifting to talk more about impact. I don't think we do want to say 90% because it's not realistic. We are really focused more on impact, and I don't know if you're familiar with the Fundraising Effectiveness Project. Are you? It's something. I think it is, I don't know, David, you might know, is it, I think it's the Association of Fundraising Professionals, and it may also be the BB Wise Giving Alliance that has developed this way to talk, developed this project and this tool to talk about how, the cost of fundraising and the impact. That's not what this is about, but I just wanted to point it out that I don't think development departments want to say 90% because it's not realistic. And I don't think we want to send that message.
Let me just make two quick points on this subject before we move on. Just coming from my perspective as defense counsel and trying to keep people out of hot water. Number one regards consumer complaints. This goes back to Yael's point. There are more charities to regulate than there are regulators. No matter how good they are at playing whack-a-mole, they can't whack everyone. So I always find myself counseling clients, don't do something that is going to result in consumer complaints. I know that sounds obvious, but when you are telemarketing and the recipient of the phone call says, I'm on the FTC's do not call list. The rebuttal in your script is not, or should not be, well, but we're calling on behalf of a charity. We don't have to comply with that. Because, yes, you're technically compliant with the law, but you call that person 3 more times and they're going to write maybe their local BBB, maybe their local attorney general. And if resources are scarce and you don't know who to go after, I imagine consumer complaints are going to put people at the front of the line. The other thing that I've been stricken by over the past few years is how much words matter in the script or in the solicitation. And this is an advertising claim, but we talked about disclosures. I'm calling on behalf of the C3. To me, very clearly evinces, a third party. You yourself are not the charity. I've seen so many scripts. I'm calling with the vets. I'm calling with the ladies if it's a breast cancer charity, and it muddles the relationship. And particularly elderly call recipients will think, "Oh, I'm talking to the charity," and that's a huge red flag. So even 1 or 2 words really does matter here.
So can we talk real quick about some things that you can do to protect yourself? I advise clients frequently to, make sure you have a good contract in place that spells out, the services that are being provided, how much you're paying to the professional fundraiser. Make sure that you have review and approval rights over scripts and mailers. This is your organization's brand. It's very, very valuable, and you don't want to just hand it over to a professional fundraiser who's going to draw up scripts based on, information that's on your website that may or may not be current. So it's good to regularly, request or require that the fundraisers share their scripts and their mail pieces that they're sending out on your behalf to make sure that, they are capturing programs and services that you are focusing on in the current year. So just a few things to keep in mind.
That's an excellent point. Let me jump off of it because this relates to the private TCPA sub-bullet, contract language. You want to make sure that the contract makes clear that the fundraiser is the agent, the charity is the principal. And so the charity has, like Atitia said, final reviewal rights. This stuff has come up. TCPA litigation is rampant. Most of those cases, virtually none of the cases are brought against charitable fundraisers. But in recent years, a few have been. And what the TCPA, for those of you not familiar with it, it prohibits using what's called an auto dialer to call people without consent and to call people who are on the do not call list. So it's sort of an FCC-FTC overlap. There is an exemption for calls made by or on behalf of tax-exempt nonprofit organizations. That's why you very rarely see cases filed. A few years ago, we started seeing them. And these are professional plaintiffs, and you want to talk about bottom feeders, they're on the private side too. And the allegation is these weren't really calls on behalf of the charity. These were calls on behalf of the fundraiser. So far, those cases have been unsuccessful, but they're going to keep coming. And by the way, lest you're sitting there thinking, all right, guys, we get it. We're the good ones. Like, we're not the bottom feeder charities. The last TCPA case filed, which was this year, involved Anthem, the huge insurance company, Anthem Foundation, and the American Heart Association. And a woman signed up for, consented to receive text messages about CPR classes, and started getting text messages that said AHA/Anthem Foundation, and found a lawyer to come up with some newfangled theory that alleged these weren't really texts from the American Heart Association. This was a commercial enterprise designed to benefit Anthem Inc., the for-profit. That case got thrown out. I represented a bottom feeder fundraiser that was successful in a case, also brought into the TCPA. And I've heard from the plaintiffs' lawyers that say, well, we're going to find the right one. So a lot of this comes down to agency. You want to make sure that the donations go to the charity, not through the fundraiser. The correspondence comes from the charity, not from the fundraiser. Just some food for thought. All right, so enough about telemarketing. There are some other business models. I know thrift stores is a big thing these days. We've seen some enforcement actions in Minnesota, Washington, Michigan. I know it's big on the New York radar. So what are I don't know if people here are involved with thrift store issues or clothing or gently used household donation programs, but it is a thing. So what are the issues?
So it turns out that people have a lot of stuff that they don't want. And if you can find a way of making money off of that stuff, you have potentially a great business. Nothing wrong with that. Then if some of that money can go to charity, that's great too. The problems from the regulatory standpoint come when a for-profit business kind of covers itself in the halo of charitable giving and really creates the impression to the public that it itself is a charitable enterprise. So people think that really the full value, whatever that is, of the goods or of every good that is donated is going to charity, or that the actual sale price of the good is going to charity. What I think, and I don't know, I'm not an expert on every permutation of this business model. The most common one I think that we're seeing is a for-profit business. They're doing all the work of dealing with this clothing, which I think is a substantial effort. So I'll grant that. I once volunteered, I think after Hurricane Sandy, at an armory that was sheltering a lot of people that had been displaced. And my job was actually to deal with the clothing donations that came in, and we were housing elderly and disabled people. And everybody from Park Slope, Brooklyn was bringing their size 2 designer jeans, and their dirty baby clothes.
I know.
So yes, it's a time-consuming, laborious process. But so the clothing comes in. The contracts often provide that the charity will get a bulk rate for the clothing. So it is per pound, I think. And then the clothing gets sorted, and whatever they decide is sellable gets sold. And 0 part of that sale price goes to charity. That's the for-profit part. And whatever is not sellable might go overseas or might be recycled. Again, if that's, there's many levels of inquiry here. But I think the largest risk is if the realities of that business model are really being obscured in order to encourage donations. And if people think, again, that the purchase price of the goods is somehow benefiting charity, in some instances it's really only the bulk price of clothing and not of household furniture. And meanwhile, the thrift store has images of people donating household furniture and saying this is benefiting charity. So I think that there's a way to do it right, but it's important to be mindful of those concerns. And I think there's an ongoing case in Washington State. There was a settlement in Minnesota and other areas where this business practice is under scrutiny.
So I'm very familiar with this business model. I was involved in a Minnesota case involving a thrift store and some charities. It seems to me that the risk is in the advertising. If it's sort of the in-store, or sometimes it's on the clothing bin that you see by the side of the road. It's representing to people that every time you buy, money is going to a charity, or with every piece of clothing that you put into the bin, when that is not technically true. I know that under some of these contracts, the thrift store is paying a monthly fee that is resulting in literally millions of dollars per year to charities who need them. And I tend to advise them against advertising in the store. Just operate your store, make money, and there's not illegal to make money. But you're right. I mean, this is an interesting business model. It's shifting a little bit. I had an issue with the Minnesota case because they basically concluded that the for-profit thrift store was ripping off the charity, but also tried to bring a case against the charities for being ripped off, which I didn't think was good enforcement. But that's just me. Online, social media, mobile giving, new technology ways of giving. What are our thoughts here?
Everything is online these days. You see tons of social media promotions, like our Facebook page, and a donation will be made to this organization. Post a picture on Instagram and a donation will be made. Use this hashtag and a donation will be made. You see this everywhere. And, mobile giving, text to donate to certain charities. I think the key here is, again, I would advise clients all the time, make sure you have good contracts in place with these for-profit companies, these vendors. Make sure you fully understand what they're providing to you, because depending on how the relationship is structured, what they're doing for you, the platform or the vendor could be considered a professional fundraiser, triggering registration and disclosure requirements. And I think regulators are still trying to figure out how to navigate this space, because it is new, and it's not terribly new, but people are doing more innovative online fundraising. And so again, just making sure you peel back the layers of the onion and know what you're really getting yourself into, having clear disclosures, transparent advertising.
I think that's right. I think regulators are still grappling with whether this is a whole different animal, like I said, that requires new regulation, or whether the old models of regulation apply. So I think some of that is, to be seen. new laws are not easily passed, new regulations, it's a little bit easier. I think the concerns, again, from the regulatory point of view are false advertising, hidden fees, whether donor intent is being respected. That's a really big one. And then, I think privacy and data concerns need to be on your mind.
So I think I'm going to attempt a bit of time management, and I'm not going to do well at it. I think we have about 25-ish minutes left. I'd like us to talk just a few minutes about things like crowdfunding, which are kind of new and hot, but I have no idea how to counsel clients on them. And then we have some questions, and we can just answer some discrete questions from the webinar, and then we'll go enjoy our cocktail reception. So I know that I've heard crowdfunding raised at NASCO. I know that there was a presentation on virtual and augmented reality at NASCO last year. No one quite understood what it was.
I put that in the slides because it was in this NASCO presentation, and I was like, I don't really know why we're talking about this, but apparently it's something that's being done if you have a very expensive, fancy gala, apparently, and then you put the goggles on the table, and there comes a moment in the presentation where everybody puts on the goggles and you can take a virtual trip to the village where the well is going to be dug, or you can visit the museum that's being funded, or go back in time to, New York City during the Depression, because so why is this an issue? I think there are some issues, again, of the potential of fraudulent misrepresentation. Are you really building that well? There are also issues, I think it gets very emotional, and there are issues of consent. I think people are still kind of freaked out by it. And then getting really out there, we actually heard cases of biometric data being collected through these models, and then that being kept by the company, the for-profit company doing the fundraising or doing the virtual reality. So just as, your donors are providing their personal information when they donate online through crowdfunding platforms and query what control do you have over that, I guess in this instance, your donor's heart rate and receptivity to certain messages was being gathered. I don't know. I don't think there's a New York statute on that.
This is why NASCO is interesting, because you hear about these different types of fundraising models that are coming out, and hearing from regulators, like, how are they dealing with these issues?
I shared this with both of you. There was an article that came out maybe only a week ago, noting that Facebook is now allowing brands and celebrities, influencers, to promote or solicit donations for charities on Facebook pages, and we thought that might be an interesting sort of an interesting thing to talk about here. Query whether does that magically convert Facebook into a professional fundraiser. Or is this just sort of a technological platform that's helping people? I don't know if you have any thoughts on that.
There are tons of platforms out there that provide, again, different services. There are platforms that allow a charity to go on there, create their own solicitation page, and the charity is controlling everything. And so in that case, and where the funds are going directly to the charity, you're not going to trigger professional fundraising issues. But then there are other platforms, for example, Omaze or Charity Buzz, where the for-profit is pulling these cool experiences where you can, donate your money will benefit a certain charity. And if you win this experience, you could win a trip to the Star Wars set. There are tons of platforms. So you have to look, as I've been saying, look at what the for-profit company is doing. Are they pulling everything together for you? How does the flow of funds work? Is it going directly to the charity? Is it going through the for-profit and then they're retaining a percentage of fees? So you just have to look at the facts of each case.
So what do we have, about 15, 20 minutes? We have a bunch of questions from the webinar. We're not going to hit all of them, but why don't we haven't previewed this, so this is unscripted, folks. But let's try a few. Is a subsidiary of a charitable organization which performs fundraising for the parent organization considered a professional fundraiser? I know that under virtually every state's law, bona fide staff and employees of the charity are sort of exempted from the definition of professional fundraiser. My instinct is the answer is no to this, but do we need more facts, or is this more complicated than I'm making it?
We could need more facts, says the skeptical regulator. Yes, generally bona fide staff, directors, et cetera, don't need to register. I guess the question is bona fide. Have you just set up an in-house subsidiary? I mean, if it's just your development arm, your development department, that doesn't need to register. But if there's some reason that you spun off your fundraising, to me, that potentially raises issues.
Fair enough. So we had talked about commercial co-ventures earlier. This is sort of an open-ended question. Can you explain more about why commercial co-ventures are problematic? Sort of going back to what we talked about earlier, I think a lot of this is an advertising issue. Remember, these are for-profit brands that are trying to wrap themselves in what we call the halo effect by attaching themselves to a charitable cause. With every purchase of X, we will donate Y to a charity. I'm sure the brand wants to do legitimately good work, but they also want to sell products. And if making that representation is going to make a purchase more likely, you want to make sure that your representations are truthful and accurate. But there's also a component of this of making sure that the money really is going to support charitable causes and that the charity is itself protected.
Right, and that's why these statutes have registration requirements and record-keeping requirements so that the regulators and the charities can ensure, that the money is, or the representations that are being made, the for-profit CCV is following through with what they're saying they're going to do.
I mean, I wouldn't necessarily use the word problematic, but I would use the word regulated and deserve your attention.
I like that answer. Okay, I think I understand this. Does fundraising council need to register if they do not solicit funds? So by definition, or by most states' definition, fundraising council do not solicit funds. Professional fundraisers, or in some states, solicitors, are the ones that are actually directly asking for the donation. In virtually every state that I'm aware of, fundraising council are the parties that help plan, create, they might do graphic design for the website or help with the script. So they're sort of behind the scenes helping with the solicitation without soliciting themselves. And in every state but one, they also don't take custody or control of the donation. For some reason, Ohio is different. In Ohio, under Ohio statute, it's, plan, direct, create, assist, blah, 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 or take custody and control of the funds. And so Ohio's a little bit of a hiccup. So I guess the answer to this question is we assume that fundraising council are not soliciting funds, but if you otherwise meet the definition, then yes, you have to register.
Right, and just to add to that, While both professional fundraisers and fundraising council need to register, the burden is slightly greater for professional fundraisers. There are usually bonding requirements and more regular reporting requirements, whereas fundraising council, who's not asking for contributions, doing the behind the scenes work, the registration and reporting is a little less burdensome.
There's a question back there, Camille.
Hi. At the risk of beating a dead horse, I wanted to take the conversation back really quickly to commercial co-ventures and just had a follow-up question. Atitia, earlier you had mentioned, it's important when partnering between a nonprofit organization and a for-profit corporation that you have really locked up agreements that, kind of set forth very clearly what it is you're going to be getting from this relationship. I was wondering what your thoughts were in terms of corporations or other for-profit partners that are insistent upon having guaranteed minimums and guaranteed maximums, but like no matter what, whether you say you're going to get $1 for every shirt that you sell, you're going to get a certain amount of money anyway. Is it sufficient for you in that kind of situation to have a disclaimer at the bottom in tiny print that lays all that out, or would you say that that's kind of inherently misleading? I guess interested in hearing what the regulator perspective is. So thanks.
Sure. So if a for-profit entity is conducting a charitable sales promotion, a CCV promotion, there are specific disclosure requirements. So disclosing the per unit donation amount, so whether it's $1 per widget sold or X% per widget sold will benefit ABC charity. That must be disclosed. And if a company decides they want to have a minimum or maximum on the donation, that has to be disclosed as well. I think the seminal CCV case is deals with Yoplait back in the late 90s, where Yoplait advertised, for each yogurt sold and the lid redeemed, Yoplait would donate $1 to a cancer charity. Well, under the lid, once you purchased it and opened it up, at that point there was a disclaimer that there was I can't remember, $50,000 or $100,000 maximum, and Yoplait was sued by the I think Georgia Attorney General for failing to make that disclosure at the point of the solicitation, the sale. It wasn't until after the consumer purchased the yogurt that they realized, oh, my purchase may or may not have had an impact. So because that maximum cap was not clearly disclosed at the outset, they should have donated, I think it was $6 million or something as a result of that promotion. And so, there's a huge difference between $6 million and $100,000 donation cap. So it's very, very important to understand whether the CCV is going to have a minimum or maximum donation amount and making sure it's clearly disclosed in the advertising.
Hi, I have a follow-up question on registration requirements for Fundraising Council. Do Fundraising Council, are they required to register in all of the states that their client is registered in, even when their scope of work may not include the outreach to those states?
So I have advised clients to register in the states in which you're providing services. So an organization may be registered to solicit nationwide, but if you are a fundraising council hired to help target, donors in a handful of states only, on the West Coast, then you would only register as fundraising council in those states in which services would hit.
But the trigger sometimes is the organization's registration, and they will look at the list of council.
Right. So,
am I correct? And so then you say, well, I don't work on that stuff.
Exactly.
Yes.
Yeah. Okay.
I've heard of that happening. That's our registration department, but that's kind of an easy answer. We might ask for the contract.
Let's get to one more question because we never really talked about direct mail, and this came in from the webinar. Can you describe what legitimate above-board charities should be concerned about regarding direct mail? I think really two issues in my mind come up. One is basically analogous to what we talked about with telemarketing, disclosures, truthful solicitations. I think in every state's charitable solicitation law, a solicitation is defined as both written and oral. So, if you're a telemarketer who's accustomed to making the required disclosures that you're a professional fundraiser, the charity on whose behalf you're soliciting. In some states are more onerous. Minnesota requires a statement about the tax deductibility of the donation, and I think the city and state of where the fundraiser is located.
I think the IRS requires you to state if it's not tax deductible.
There you go. So we counsel our clients to make those same disclosures in their mailings. Another issue is, and I only know this because I've been dabbling in postal law recently, to my chagrin. Charities, nonprofits are subject or eligible for nonprofit postal rates, which are discounted from standard mail rates. So we've had situations with clients where they partner with, let's say it's a nonprofit university partnering with a for-profit publisher to mail newsletters. Does the newsletter qualify for nonprofit postal rates? That's a cooperative mailing issue. And it's really similar to the agency issue that we talked about earlier. Who is creating the content? Who is in charge of doing this? And again, you want the nonprofit to be the principal and the for-profit entity to be the agent, or else the Postal Service will consider it a cooperative mailing, not subject to postal rates.
Eric, if you get to bring up postal rates, then I get to bring up the other super sexy topic of joint cost allocation.
Oh no. Isn't it time for the cocktail party?
Which is a real issue when it comes to direct mail, and I'll try to make it fast, but it's come up in kind of very high profile organizations. I try not to bring up, just to focus on the real, like the outlier only bottom feeder organizations. But there's an organization called Wonderwork, which is now in bankruptcy. I'm actually not commenting on the legitimacy of the organization, but Wonderwork did this thing where, so joint cost allocation is when you send out a mailer, and maybe the mailer is doing two things, right? It's serving a fundraising purpose. It's also serving a programmatic purpose. Maybe the mailer is raising awareness or educating the public about your issue. And that happens to be one of the activities in your certificate of incorporation and in your IRS 1023. So the IRS says that you should be able to expense the cost of that mailer in part to programs. And why do you want to do that? Again, it goes back to this idea that you want to maximize the amount of your expenditures that are going to program services. And it's not just a game, it can be completely legitimate. If I am an organization that really focuses on public outreach, then it totally makes sense that a part of my program expenditure is going to be said outreach. While Wonderwork was raising money to help fund surgeries for children overseas, I think like cataract surgeries and stuff like that. And the IRS says that in order to report this fundraising or this mailer to program services, it has to meet a few tests. It has to meet the audience test. It has to be going to people who could help you fulfill your mission. So if your mission is educating children about, I don't know, help me out here, educating parents about child safety, and you send your mailer out to parents, and you got your lists from various parenting groups or whatever, you're going to meet the audience test. If you're sending your mailer out broadly indiscriminately, you might not meet the audience test because you're not targeting people to whom your program is focused. You also have to meet the content test. So your message has to include some sort of call to action. Again, it has to be consistent with your mission. So in the case of Wonderwork, they had pages and pages of verbiage about the work that they do, but their only call to action, their only feasible call to action was give us money, because there's nothing that U.S. donors can do to help them provide cataract surgery overseas other than give money. So anyway, the bankruptcy examiner decided that this joint cost allocation was totally bogus, which then had a kind of cascading effect on other things. So circling back to the question, legitimate organizations will also take care to make sure that any program services allegedly being provided by this mailers are really being provided.
I know I've seen numerous fundraising contracts where the words, it's usually the preamble, whereas charity A is hiring a fundraiser B for a call to action, and it's sort of put into the contract almost like magic words that will somehow, it's like a protective cocoon. The contract is nice, but your actual practices have to be compliant. Are we good? Thank you very much, Yael, Atitia, and thank you all for coming. Please stay for the reception, and that's it.